Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Karen Witte, Assistant Professor of Law at Washington and Lee School of Law. We will discuss her article, The New Insider Trading, which will be published in the Arizona State Law Journal. So welcome to the show, Karen.
Thank you for having me.
Yeah, my pleasure. This was a fun article to read, especially because, I had some exposure to securities law and securities regulation when I was working at Sullivan and Cromwell. But for listeners who may not have practiced in the securities area, I wonder if you could start by just explaining to people what exactly insider trading is and why it's prohibited, right? I imagine a lot of people might have heard the term, but not really understand exactly what it entails.
Yeah, Brian, it's a great question. And really, that sort of very general, basic question is the $1,000,000 question in some sense when we talk about insider trading. It is trading securities based on information that is considered material and not public. But how we regulate that really has been the conundrum that's still in front of us today. In fact, just last week, the U.S. House of Representatives passed a new bill, and so it's going to go to the Senate. But again, trying to get their arms around how we prohibit people from trading on, essentially secrets or confidential information. And so, really, the question is, what is the problem with that? Isn't that something that happens pretty regularly? The answer is probably yes. And so, who is injured when that happens? And so there's all these fascinating articles and theories about this and sort of who is injured. Is this a theft of property of the company that, the information is about? Is it a fraud on the market, meaning our markets now are not fair because certain people have an advantage? So all of those questions get wrapped into figuring out, this type of, how are we going to prohibit this activity? So what's fascinating, I think, about insider trading is that for a long time, it was seen as if you have inside information, you just can't trade at all. That was just an open, shut, done deal. That was, it's called basically the disclose or abstain rule. So if you have inside information, you have to abstain from trading, or else the alternative is disclose it, make it public information, essentially. And in the 80s, Justice Powell basically carved out, in some way, an exception to that. And the idea was that there are some instances where insider trading might not be bad because it gives us, an understanding. And, if there is a company that is entirely fraudulent, maybe we need to make sure the market will react to that. So there's a very famous case called Dirks versus SEC that is passed and gets decided in 1983, and Justice Powell writes that opinion. And there's so many great articles about this decision and how it does create a bit of a watershed moment for insider trading, because essentially, and I should say that this is particular to an insider trading scheme where there's a tipper, so someone who knows information, and they tip someone else. And that other person, the tippee, is who trades. The backstory of the case was that someone who was an insider realized that this one company was sort of rife with fraud. Imagine sort of an Enron level fraud, and he basically tries to be a whistleblower about it. And there's more sort of detail that, but essentially it is nearly a whistleblower type case where he tells people this is a fraud. You should be aware of that. And he works for a brokerage firm, so some of his clients traded on it. So not only was this sort of the SEC realizes that there is fraud in this company, and so they go after the company, but then they turn around and also go after this guy Dirks, who's essentially the whistleblower in some sense, and they basically say, "Hey, you tipped other people, and so that was essentially trading on inside information. You were a tipper." And so it was one of those situations where that seems sort of unfair. Everyone was trying to sort out how this will work out, because it's true that, like, if he had tipped this inside information and someone traded, that's insider trading. So Justice Powell carved out essentially an exception that says, well, hold on. In tip or tippy situations, we're going to say that, if the tipper gets a personal benefit from the tip, so if there's some sort of quid pro quo, which is certainly a phrase of the day, this is the same idea there. If you got something out of tipping, then it's insider trading. But there are certain instances where we hope that people will disclose information if it, gets to essentially what we call price discovery. That if it is helpful, if it's a whistleblower type situation, you're doing this without getting any benefit to yourself, that might be a good thing. So from that case, we get this whole new idea of, well, what does it mean to have received a benefit for tipping? And that has set us on this path of the doctrine of insider trading, where people are trying to get their arms around that. One last thing I'll say about your question there is that insider trading is not in the code, meaning it's not prohibited by statute. It is falls under, to bring a case for insider trading, you bring it under Section 10B or Rule 10b-5 of the Securities Exchange Act, or the Rule 10b-5 is the SEC regulation that is affiliated with that. And it just, in that case, the prohibition simply says, it's unlawful to trade or use any, it's unlawful to employ any device or scheme or artifice to defraud, or to make any untrue statement of material fact, or to engage in any act or practice or course of business which would operate as a fraud. So the term insider trading isn't in that. And instead, we have essentially a prohibition on an activity that is driven entirely by common law. So each new case that comes up, there's a new sort of contour or definition to what the activity is we're trying to prohibit. So you can see when it's set up in that way that a lot of this will be driven by courts and by each new set of facts that a new case brings. That adds a new sort of definitional quality to this activity. That is rife for a lot of broad interpretation, I will say.
Well, so just to get super clear about it, under the kind of Rule 10b-5 version of insider trading, how is the government defining insider trading in what I understand to be kind of almost like a federal common law type way? And what kind of limits, if any, did the courts place on the ability of the government to expand the definition of insider trading? Because it sounds like that's what Dirks and other cases were doing, if I'm right.
Sure. So essentially, like I said, the at base, it is trading on material, non-public information. And so I should say there are a few different theories under which the government brings it. There's the classical theory where I am the insider and I trade for my own benefit. So that's a pretty open shut deal. Like, I'm not allowed to trade because I am, the attorney for a firm that's going to merge, or for a company that'll merge. I have some access to information and I trade for my own benefit. And that's a pretty open shut, what's considered a classical theory. The reason Dirks and some of these other cases get a little more interesting is that, and there's more color to this, is because it's not that. It's someone who is the insider then tipping someone down the line. And you get, in some of the more recent cases, this idea that there's almost a daisy chain of information in some places where, you can't ever link the final trader to the original source of information. And amazingly, that is insulated under the Dirks personal benefit test, because the link there was, well, yeah, if this information gets out and you're not benefiting from leaking it, essentially, then it is what it is. It's sort of where Powell came out on that. Like, well, if you can't prove the personal benefit, then maybe this is just, information that is now, essentially available to the market. So maybe we shouldn't be as worried about that. But that does, when you think about insider trading, or you watch a show like Billions, or, Wall Street, or whatever, sort of when you imagine what insider trading looks like, you can see how that, insulates what is, kind of exactly what we think about when we think about insider trading. These hedge funds or various other firms that get, the edge that basically could be inside information. But if they are far enough removed from the source of that information, they can insulate themselves from prosecution or from an SEC enforcement action. And so that's why this definition of what does it mean to get a personal benefit if you were the tipper has dictated so much. There's been numerous cases that try to sort that out. So personal benefit under the Dirks test is a pretty obvious one, a pecuniary gain, a true quid pro quo. I'll pay you for that information. But then there were two other categories that Powell included in Dirks that he said would count as a personal benefit. And that's where it gets sticky. And one of those was considered reputational benefit. That could translate to future earnings. That's already a bit of a nebulous idea. And then the last one was a presumption of a personal benefit if the person you tipped was a trading relative or friend. And that was essentially, if I'm tipping off my spouse, and it's basically someone essentially trading in your shoes. So it's just like almost a derivative of the classical insider trading. Someone who's so close to me that I might as well have been doing the trade. And so what has been interesting is that there have been sort of questioning, truly the definition is a trading relative or friend. Like, what does that mean? And so you get more and more cases where how far does that extend out? Who is a trading friend? And so that's where it gets interesting, at least to me, in terms of like now the distance of a relationship might determine if you could be prosecuted for insider trading or not. So that's sort of where we are. That's the background of some of the case law up until now.
Well, so I wonder what kind of problems that creates from a regulatory perspective. I mean, do you see the primary problem as being the inability of the government to regulate behavior that we might want to see curtailed? Or is it more of like an uncertainty problem, like both the government and or the potentially regulated parties just don't know when liability attaches and when it doesn't? Kind of both of those, or something else that I'm missing?
I think both to some extent. I mean, certainly the latter idea that you brought up begs sort of almost a rule of lenity type issue, like we saw with the vagueness almost, like what exactly is prohibited, and that's hard to get your arms around. And so, tie goes hopefully to the defendant on that if it's hard to understand what is prohibited. But then, I do think there's also just the general idea that it's hard to figure out what the relationship is, and so how do we curtail it? So I should say that this idea teed up sort of me looking at this more closely, and then there was a new case that came up to the Second Circuit that was just argued last week or a few weeks ago that brought up what I'm sort of getting at with my paper, which is what if we can end around all of this? And so there is a criminal code, a different code that prohibits what is just called securities fraud in general. And the statutory language on that is sort of equally nebulous, just sort of an intent to defraud. Insider trading is not mentioned in it. And it hasn't actually been used very often as the grounds for an insider trading prosecution until a little bit recently. And even then, there's only been a few cases. But this interesting case that just came to the Second Circuit had the rare instance where the jury, when faced with an insider trading case, and the facts there, decided that they could only they convicted the defendants under this general securities fraud. It's actually 18 USC 1348. And it's just, again, a blanket, just general fraud that relates to a security. But they couldn't, under the same facts, convict them under Rule 10b-5 because, as we now know, they had to walk through all of these hoops of figuring out if there was a personal benefit and who knew about that, and did the tipper know about the benefit, or the tippee know about the benefit. And so it was one of those things where the jury, I think, was like, wow, insider trading, as we have sort of has been developed in the courts over the last 50 years is hard sometimes to pin down. So they just punted in some sense and found the defendants guilty under just a general securities fraud provision of the criminal code. So my argument is a little bit suggesting that maybe all of this hubbub, all of this, efforts to try to define that personal benefit concept may be circumvented by going forward with criminal insider trading under this other statute, and that might be something we see more of. So that's what I try to tackle in my piece.
Well, so as I understand it, this statute was part of the Sarbanes-Oxley Act. I wonder if there's any indication as to sort of what it was intended initially to cover, and if you could talk a little bit about, like, to date, how courts have interpreted it to also cover insider trading, whatever else it was intended to do.
Right, that's a great question. So to answer the first part, you're correct. It was passed as part of Sarbanes-Oxley, and it was fashioned on sort of the general mail and wire fraud. We've seen some bank fraud, healthcare fraud, similar statutes that, again, are sparse in some sense in terms of what they cover, but generally cover a basic fraud scheme, and then depending on what industry that occurs in, if it's in healthcare, it would be healthcare fraud. So the text of it really just says it would be prohibited to defraud any person in connection with the sale of a security, or that's essentially the gist of it. And so it was passed, like you said, in 2002 as part of Sarbanes-Oxley. The legislative history from that indicates that it was intended to be as broad as it could be, to sort of ensnare any and everything. I think Congress was sort of so shocked and frustrated by the Enron, sort of what really launched Sarbanes-Oxley and the events that drove Congress to pass that fairly sweeping bill, that they didn't want to pigeonhole it to specific types of activity. And in fact, Senator Leahy had pushed for this and just said this is really to supplement any, technical securities laws where defendants could find loopholes. Like, we do want this to be this umbrella law that would catch as much as possible to assist prosecutors in finding, being able to meet elements that where they might not in other situations. So it maps on somewhat to the insider trading for that reason, which is there are some now tricky elements you need to show to prove insider trading under 10b-5 that you wouldn't need to show under 1348. However, there haven't been many trials or sort of cases being brought under this charge for insider trading. There were two important ones that came out of the Northern District of Georgia. It seems there maybe was one sort of creative prosecutor there who realized they could bring an insider trading case. In that situation, in both of those cases, they brought the charge for insider trading only under the 1348 charge and not under 10b-5. The case I referenced earlier in the Second Circuit brought the charges under both, and that is where the jury could only find the defendants guilty for 1348 and not 10b-5. Again, because to meet the elements of 10b-5 with this personal benefit test, the jury just essentially said we don't see that, but we do see just a general securities fraud activity. So it's a new thing. That's kind of why I was so fascinated to dig into this. It hasn't been brought up a lot. And I do think maybe prosecutors are starting to see this. One thing I will say is that it is 1348 is found in the criminal code, meaning only the DOJ would bring this type of a case. Whereas 10b-5 is one that you can have both criminal and civil enforcement actions under. So the SEC can bring civil insider trading actions, and the DOJ can as well. So it would cut the SEC out, which query if that sort of misses the purpose of, what we're trying to regulate in some sense. So that is an interesting sort of difference between those two statutes as well.
Well, are there like textual or contextual reasons to think that courts haven't or won't read the personal benefit test from 10b-5 into this 1348 provision?
Yeah, I mean, that is really sort of the nugget of what I'm so interested in, because of the way that Dirks is written, it carves out situations wherein insider trading is not per se illegal. And so if that's sort of what I was trying to wrestle with in this article, is that if we then just stand up it's not new, it's from Sarbanes-Oxley, but we have this other means to charge it, and we just import essentially insider trading as bad, I think that's missing some of the nuance we've seen that the courts have wrestled with over the last 50 years in 10b-5 jurisprudence. And so that was one of the things I was trying to get at. And the first thing I looked at is whether or not these are different charges at all, like whether or not there's a potential Blackburger multiplicity of charges issue. If you're charging these two things, aren't you doing the same thing? And that should be, essentially a violation of due process, really. And it seems that, in the few cases where they have brought both, no one's all that worried about that, because there are some, as you point out, textual differences between the two, meaning that one, 1348 requires knowing violation. Make sure I'm right about this. The defendant needs to act knowingly, and 10b-5 requires proof of willfulness. So, whether or not that is enough to distinguish the two, it seems that, no one seems to have been worried about that. But, I do think that's an interesting idea. Do we import the 50 years of how we have defined insider trading into a prosecution for insider trading under a broader securities fraud umbrella? And the answer is I'm not sure. We're still sort of sorting that out in the courts. And I think another interesting idea there is, what is the implication if we do or do not do that? Do we incorporate the personal benefit test into 1348, or is it just a general new, hey, I found intent to defraud? That's all we need essentially here, and a scheme to defraud. We pass go, and you're guilty under 1348. Does that lose a lot of the nuance of insider trading?
Well, so I wonder if you have any thoughts about how the DOJ is likely to use 1348 in the future, and more importantly, maybe thoughts about, assuming that they do start to use it more in an insider trading context. I mean, what do you expect courts to do with that going forward?
Well, I mean, we'll see when we get the Second Circuit decision in the case I was referencing earlier. I think it's pronounced Blasiak, but it was just argued. So there was sort of an idea of teeing that up. What does that mean when you have this jury finding guilt under one of these statutes and not the other? And we haven't imported the definitions of the securities fraud to 1348. So we might see that the court say this is fine. I see no problem with operating under this new statute, and there's scant jurisprudential precedent on this one, but that's what it is. You get sort of a new chance to figure out how you would prosecute insider trading on essentially a blank slate. And if they give that green light, I expect we would see a decent amount of prosecutions being brought under it. I should also note that this isn't entirely novel, because the DOJ has brought insider trading cases under mail and wire fraud, so just the general even more broad, not even related necessarily to securities, but just we found evidence of a fraud and the use of mail or wires. And so that is not a new idea. So there certainly are some critics who think this isn't anything different, and that the DOJ always have had this at their fingertips under one type of fraud or another. But I do think it would be an interesting to see. I think the DOJ would avail themselves of this statute for insider trading cases more often, certainly.
Well, so Karen, in closing, at the beginning of the interview, you referenced sort of the way in which our kind of theory of justification for insider trading depends upon our regulating insider trading depends upon our sort of broader theory of justification of securities regulation and kind of what interests we're trying to promote. I mean, I wonder if you could talk a little bit about how that theoretical question might or perhaps should inform the way we think about, arguably expanding the scope of government regulatory authority over insider trading through this provision that you identify.
Yeah, wow, that's a great question. There are sort of foundational theories here, or bases about what people think is the best theory to move forward in terms of regulating insider trading. And we've seen, there's a number of excellent securities law professors who tangle with this fairly regularly. The sort of driving, I think, or most common theory is really this idea of there certainly is a property rights idea here. This is the equivalence of a theft of corporate information. So you've seen that get a lot of traction recently, and so that is what we are trying to curb, and that is what we are punishing, is that you have stolen something. The victim here is the company whose information is being misused. That is certainly, like I say, a leading theory that we've seen promulgated by a number of prominent securities law professors. There's, like I said, this other idea that there's a general fraud on the market, meaning the market is now an unfair playing field. And so the market itself is a victim here. There's certainly people who would think that the other sides of the trade, if such a thing is available for the short sellers, or someone who still is injured because someone had a trade that benefited only them via inside information. I think that is why I find insider trading such a rich area to explore, because how you define the activity you're trying to prohibit or to regulate, it sometimes is dictated by who you think has been injured or hurt. And sometimes, certainly in insider trading, that's hard to pin down. So that's where you do get these new schools of thought or different streams of thought of how to regulate it based on who we're worried about protecting. And so like I said, I think as it stands now, most people still do fall under the idea that the company is the one that is the victim. There's some breach of duty between the insider and the loyalty that person should have to the company whose stock is being traded. And so that I think will still be defining sort of how we regulate it for the foreseeable future. But there's a lot there.
Well, Karen, thanks so much for coming on the show. It sounds like a really dynamic area of law that's changing right at the moment. It'll be interesting to see where the courts go with this going forward.
Now, thank you so much for having me. This has been a delight.
Wall Street Daily cries, phonograph record 203 3/8. Yes, my baby, she told me I got work to tell you. What I need is more money, 'cause my baby told me so. Buy low, McGilliam, buy low, McGilliam, buy low, sell high. The Wall Street Daily cried. Boom, bam, jim jam, boom, bam, jim jam, boom, bam, jim jam. The Wall Street Daily cried. Turn around to do my best. I gotta work, I told you. Stop my head in a hornet's nest, 'cause my baby told me so. Tickers working overtime, intricate, I told you. U.S. Steel and radio, new form rubber, say Idaho. Gotta make my baby some dough. Buy low, my Gilliam, buy low, my Gilliam, buy low, sell high. The Wall Street Daily cried. Bim bam, jim jam, bim bam, jim jam, boom bam, jim jam. The Wall Street Daily cried. Maritime coal and coke, 203 and 3/8. Now, Stan Joe, now he says no, but I gotta work, I told you. Give me more of that capitalist dough, gotta make my baby some dough. Buy low, McGilliam, buy low, McGilliam, buy low, sell high. The Wall Street Daily cried. Bim bam, jim jam, boom bam, jim jam, boom bam, jim jam. The Wall Street Daily cried. Now I had a pig, your name was Ned. I gotta work, I told you. He was always sick and never dead. My baby told me so. Sent him down to Arkansas. I gotta work, I told you. Give him to my mother-in-law. Gotta make my baby some dough. Buy low, McGilliam, buy low, McGilliam, buy low, sell high. The Wall Street Daily cried. Maritime coal and coke, 207 and 2/8. Now, say Uncle Noah went to Yale, but he had to work, I told you. When an amorous man got off the cale, gotta make my baby some dough. Buy low, McGilliam, buy low, McGilliam, buy low, sell high. The Wall Street Daily cried. Boom, bam, jim jam, boom, bam, jim jam, boom, bam, jim jam. The Wall Street Daily cried. Boom, bam, jim jam, boom, bam, jim jam, boom, bam, jim jam. The Wall Street Daily cried. Buy low, McGilliam, buy low, McGilliam, buy low, sell high. The Wall Street Daily cried. Phonograph records, how they sell, 222 and 3/4.